Good afternoon. Welcome each one of you for the last session of the day. That is post lunch, of course. We have with us Advocate Amit Mehta. Now he has been a part of various lawmaking, and of course he is also one of the renowned advocate dealing with the real estate and other matters. Now we will not waste much of the time. So I welcome Advocate Amit Mehta. Also Sunita Godbole, you are already aware. She is the president of Women's Legal Forum for Cooperative Housing Societies. Now let us begin with the first panelist to give your views on the rights and duties of members. There are different types of the members, and then their rights and duties, and management of housing society, record keeping, and the various disputes that is happening in the management of the housing society. I request you to come and speak few words, and then we will straight away take the question answer from the participants. Yes, sir. Let us welcome Advocate Amit Mehta.
Hi, good afternoon. I know it's a Sunday afternoon, so you have to keep on pushing people to come and also participate. But Sunday afternoons are very good. You are at leisure, you have time, and there's a peace in mind to discuss. So I think we'll go into a lot of interactive discussions rather than just a speech. But coming to the subject which has been allotted between the panelists is about the types of the member, how do we classify. So you know that regularly when we keep on interacting, we use a lot of loosely worded classified names. So let's come to the actual legal words. So first is the original member. There are basically 6 types of member. I don't know if many of you know that, but there are actually 6 types of members. First is called an original member. The second is called an associate member. Then third is called a minor member. Fourth is called a nominal member. Fifth is called a corporate member. And sixth is called a sympathizer member. Sympathizer. Yes. Yeah, that's a co-owner. Associate member and co-owner. Yes. So these are the 6 legal words which we use normally for members. Now, anyone has any questions on this now? Let's go item by item. You know what is the original member? Yes. Original member is a person who is signed an agreement with the developer. He has taken a flat. He has been issued a share certificate. Associate member, I hope you are clear now as per the new bylaws.
Can he vote?
Sorry?
Can he vote?
Yes, if his name is in the agreement, and in lieu of that agreement, his name is there in the share certificate. The answer is yes.
Can he be elected?
Yes, he can be elected. He is like a regular member, but he should be fitting the definition of an associate member as per the new bylaws. Third is a nominal member. Yes, anyone knows who is a nominal member? Yes, a person who is not a owner, but he is the occupant there in some way. That's called a nominal member. Then fourth is a corporate member. You're aware of corporate members? Exactly. A company or an entity who is not an individual, is called a corporate member. Here what happens? An executive who is a director, general manager, and that may keep on changing. And because the company is the owner, the company is the shareholder. Minor, obviously, I don't need to define what is a minor member. And then last is a sympathizer member. Any idea what is this? Don't see Google right now. Sympathizer member is...
The easiest way to answer your question.
Yes. No, because for us it is day-to-day things, so everything is by heart to us. We go unprepared. Any question you can ask and we will give the answer. Because I am a lawyer, who is going to file a case on me? So sympathizer member is a person with whom the person sympathizes with the society, and the society considers him that he should be still a member of the society, which is very rare, but that is also one of the memberships. Yes, he gets membership of the society if the general body passes the resolution. No, he'll be living inside only, not outside. Like that, there are so many sympathizers.
So usually in cooperative society, names are on the ladies, but actually gents member is actively doing attending meetings and all.
Right.
So are they called as a sympathizer or it's just as a commonly?
No, if they are tagged as sympathizer member, then only they'll be called as sympathizer. Otherwise, no. See, many times what happens, the lady's name would be there due to tax issue or whatever the issue is. So, but normally the other spouse goes and attends it normally. But his name is in case not there on share certificate, he may not be able to vote. He may attend, but he cannot vote then.
But he can attend.
He can attend. He can attend the meeting.
Can he propose or second the resolution?
No, honestly, no. I mean, see, if everything in the general body are accommodative, then it is fine. But if you technically and legally talk, then answer is no.
So if it's a challenge in a court, then it is not.
Yes, it may not stand. Yes.
So in a corporate membership, the company owns the flat, the person staying there, does he attend meetings? No.
No, they, through a resolution of the board of directors, they authorize someone who will be authorized to participate and vote on behalf of the company. There has to be resolution from the board of directors. See, many times we ignore these things, but these things you should know. Some things that you attend with Mr. Ramesh Prabhu, you should know that there is extra USP in getting this information here.
Can the spouse of the member object to things raised in meetings, or he or she has to just come there to listen?
No, they can object, but it may not be recorded in minutes of meeting.
Nominal member can attend meetings?
Yes,
Occupant can.
yes, they can attend the meetings.
But not vote.
No,
Is it a tenant or a
no, obviously not.
Tenant or legal licensee, when he occupies the house, is he by default called as normal member, or it has to be, a resolution has to be passed?
No, resolution has to be passed. I mean, just because he is a licensee doesn't mean that he can participate or become a member. There is a resolution passed in the general body meeting. There is to be a situation and circumstances why he's been made a nominal member, and then. See, I think sympathizer members and nominal members are not so common in Mumbai. It's rare. But those provisions are there.
So family members as nominal members, how can differentiate?
Family members as nominal members. No, that cannot happen. I mean, unless the society agrees. Unless the society agrees.
Some far relatives are staying with them, how can?
No, there can be only one member, the main original share certificate holder only.
So now there is a trend of redevelopment, and in redeveloped society, existing members are drawn up. So that provision is there, the society is having office and all. Then something is like that.
Yes, society office is mandatory.
It is essential.
It's mandatory. See, now you would have known that, the plots which are other than Mahara, okay, the building proposal report in BMC takes care of all the approvals. Now Mahara has taken over the approvals role of the BMC. Bypassing BMC, now they are the approval authority for their plots, for Mahara plots. But the rules and the bylaws remain the same, whether it is a private plot or a Mahara plot or a BMC plot. If you are going slightly off the target, it's fine, because your question should be answered. So today we are not going to charge.
If there are joint members, can both the members attend the meeting, AGM?
No, only the first holder.
First holder.
Unless the second one or the first one gives the NOC for the second one, then the second one.
But both cannot attend simultaneously.
No, both cannot. I mean, attending is fine. Normally they would not, but voting will be one only.
But participation,
Normally one, only one.
only one.
Yes.
Mr. X is a member of the committee, managing committee. Now for the next term, he is asking his wife to become, she was elected also, and now she is the treasurer. So is that possible?
No, then have they transferred someone as an associate member or gift has been given or something?
Plain NOC. Yeah.
Plain NOC cannot be there, na? That person has to have a formal procedure of being an associate member, okay, or then the name has to be the share certificate. Some documentation has to be done. NOC is not the documentation.
But if he is giving his power to the wife, then the wife should be, means we have to enroll in the application of membership, the membership register should be.
Yes, you have to fill up the form for associate member.
That's the
But that can be done. I mean, you can just fill up the form for associate member. Let us not identify. If it is identified, it's fine. But you fill up the form and complete the formalities under the provision of the bylaw.
Sometime back it came that additional shares certificates have to be given by collecting 250 rupees or something like that. Is that compulsory?
No. Ramesh Tomuji can give some more idea and thoughts.
Before we try to, start society forming and all, that record keeping is very important.
Right.
So share certificate is the main, document that you are a owner or you are a member of the society. Usually, in society that is lacking, So people, it's a social work, it's out of the way you have to work, then only it's records we make. So sometimes it lost and all. So how to, make it straight right? Who is the responsible for?
See, normally there is a transition. Let's assume it's a new building. So the transition takes place in the following manner. The developer normally becomes the first chief promoter. There is a normal circumstances. Because under MoFA or under RERA, it is his obligation to do it. Society formation and conveyance. So your committee, your ad hoc committee has to be vigilant. Whether they want to become chief promoter or they are delegating you to become the chief promoter and doing the various paperwork on your behalf. So it's basically only you have to be vigilant and literate enough to understand what you have to do. It's a very simple procedure.
Cooperative law is not very much clear under 97th Constitutional Amendment to have 10 shares. That means whether existing members having 5 shares under the same folio should be given additional 5 shares, or existing share certificate along with the folio to be withdrawn and given a new share certificate with 10 shares. So even when I wrote to Deputy Registrar, I didn't get any reply. So what is the remedy here?
See, according to me it is very clear. I don't know if there is ambiguity in this. Ramesh Tomuji, is there any
There is
ambiguity?
no ambiguity, but I will explain. Maybe you can explain then
Because there is no ambiguity in this. You can give a detail about that, if you want.
See, new model bylaw says after 97 constitutional amendment, what it says, the society shall admit a new person after receiving 10 shares of rupees 50 each. That does not mean that the existing members are required to be given additional 5 shares. It is applicable to the new members. Whenever the transfer happens, anything happens, so additional 250 rupees can be collected as a share capital. Now, as a procedural aspect, that is never comes in the constitution nor in the act. It has to come in the bylaws only. What we suggest is that if at all you want to issue additional 250 rupees share, then you enter into the same share register, enter into same I-form register, and then call for the share certificate. On the backside, you endorse that additional 5 shares of 51 to 60 or 51 to 55 is issued. So you don't have to issue a new share certificate. What is the meaning of share certificate? Share certificate indicates that you are a holder of so many shares. If I can write on the backside of the share certificate that additional 5 shares are issued to you, that's more than enough. You don't have to issue a new share certificate. Are you getting my point?
No, but normally what happens, people want to have that physical addition of a share certificate by either cancelling the earlier one or adding one more.
No, we should not give new share certificate. On the same share certificate, the way we endorse the new name when he purchases on the backside. Same thing on the backside, we can write additional 5 shares are purchased. On the front side, there will be 250 rupees. On the back side, you can endorse additional 5 shares which are given. You don't have to issue a new share certificate. By issuing a new share certificate, there will be 2 share certificates of the same flat and that can be misused.
This is for mortgaging.
But actually, is it optional not to,
Yeah, it's optional.
we can retain the 5 shares only also in the transfer?
Absolutely correct.
Sir, if that is the case, if the flat is sold now, let us say, because after 97 constitutional amendment, so that person who is buying is the newcomer.
That's
so
correct.
for him, that same 5 share will continue.
That's what exactly he asked. If you want to continue with the same 5 shares, you can continue. Absolutely no problem. But if you want to issue, the law provides for issuing additional 5 shares and you can receive it and backside you can endorse it. The way you are endorsing his name on the backside of the share, same additional 5 shares can be endorsed. And chairman, secretary, treasurer will sign on that endorsement. That's enough. Okay, regarding membership, now there is a new ordinance which has come. I think you are all aware. 30th October 2018. For some or the other reason, that ordinance has been withdrawn. Now, in the new ordinance, only 4 types of members have been now classified. As against 6, now they have made 4. Nominal member and sympathizer is removed. They are no more in existence as per the new ordinance. Now they have introduced 4 classifications. First is a member, second is a joint member. Joint member means one who is holding their shares jointly or holding the flat jointly.
Co-owner.
Co-owner. Third, they have introduced associate member. The definition of earlier associate member is nothing but a joint member. Now the associate member, they are saying one can pay 100 rupees as an entrance fee, get an authority letter, and that associate member can attend the meeting. Because only member can attend, so therefore they have given one more classification. A person, even if he is not a owner, any relative, any friends can be sent as an associate member. With an authority letter, he can attend the general body meeting, but he cannot contest the election. He can vote in that general body meeting. The last one is provisional member. Provisional member means for a nominee. If there is a nominee or a legal heirs in whose name you want to transfer the share certificate, but those people are not able to get a letter of administration, probate or anything, in that case they can be admitted as a provisional member. But provisional member has a right to attend the meeting, he has right to attend vote, and he also right has to contest. But only thing, he cannot sell the flat, nor give it on legal license basis, nor mortgage it, because he is a trustee for the legal heirs. Till the trustee is transferred, provisional member will continue. Yeah.
Then the provisional member to become that permanent member, what is the remedy now?
He has to
most
get
of the time, in almost 90% of the cases, that nominee is either son, daughter, wife, husband, like this.
Yeah, there are 4 remedies which are being given. One, you can get if there is a will, you can get a probate. If you do not have the probate or will, then you go for letter of administration. Okay. And if you don't have a letter of administration also, then you can go with the family arrangement. Family arrangement. Release deed or some family arrangement you can do. Or maybe, success certificate or a hardship certificate. All that you can bring.
No, there is a release deed, there is a release deed and surrender deed.
Correct.
There is a will which will be probated. Then there is a letter of administration. Then there is a letter of succession. Okay, and then there is a family arrangement settlement.
Letter of administration. Family arrangement settlement, can you explain, sir?
It's inside the court.
Huh?
It's done in the court. See, if there are probably 2 brothers, 2 sisters. Okay, and each of them are claiming to be legal heir. And there is ambiguity about who is actually the owner, or is likely to be the owner. Then they have a family settlement agreement registered in the court by consent.
Court?
In the court by consent.
Consent.
Yes.
Which court?
City civil court. Yeah. Because that is considered as a partition suit. It's a part of a partition suit.
Yeah. What is the status of the ordinance? Ordinance right now, it was converted into bill. The bill has been withdrawn, but ordinance is in operation till 31st December 2018, and new ordinance may come in, because on 31st December 2018 the ordinance will lapse. Okay. Once the ordinance lapse, then naturally new ordinance has to be introduced. Otherwise, the old law will come into force. So we are expecting new ordinance to come in next 15 days.
But this is very wrong, sir. Because person has to spend nothing less than 6 lakhs to 10 lakhs to get that succession certificate or that probate or
Okay,
anything?
Mr. Sharma, he has to spend 6 lakhs. Let me understand. What is the value of the property?
No,
1 crore, 2 crores, 5 crores. Now, if you are not concerned with your property, whom it should be transferred, you are not making a will, you are not making some arrangement, and now there is a infighting between both of them, how a cooperative law can take care of the law of succession?
Managed in the society. It's not
The first thing is,
people can join.
let us understand, cooperative law is not a substitute. Listen. Cooperative law does not or is not a substitute for law of succession. There is something called law of succession. Mohammedan law is there for Mohammedans. There is a Hindu Succession Act. There is a Indian Succession Act. So one has to go with that succession law. So the cooperative law cannot take over the succession law. And therefore one who succeeds as per the legal terminology, he will be admitted as a member. So till such time he will be a provisional member. That is a provision made in the latest ordinance. Amit, am I correct?
You are right, and till that time, possibly by 30 minutes, the old one will continue, which I do the definition.
That's correct.
So corporate member also is merged now with original member.
See, member again will have two classification. One is an individual member, the other one is a corporate member. In the corporate member, we have LLP, we have partnership firm, we have, even partnership firm is considered
Private
as a
limited
corporate.
company.
And then we have an association of persons. Now, all this trust, local authority, company, all this becomes a corporate member. That will still continue. In the joint member also it will continue. There can be one company who is a 50% owner. One managing director could be joint owner. So even in the joint owner it can be there. So I request Sunil Deshpande to come on the dais. Sunil, come. We have Ankit Gupta also. We will be discussing on the management of cooperative housing society. Come. There are two software people. Yeah.
Sir, I have one point. You have said as per the recent ordinance, the associate member is like a proxy who
Correct.
can give a vote, etc. But as per the earlier bylaws and earlier rules, bylaws before the 2014 bylaws, the associate member whose name is already entered in the on the share certificate. Now, how it stands how would it stand against the new ordinance?
See,
By paying 100 rupees, you would become associate member then.
I agree with you. Same associate member now will continue. Only thing, he will not be able to contest the election. His name, if it is written on the share certificate, it will be removed. If he is not owner of the member flat, then his name.
Earlier, you would pay 100 rupees
Correct.
and become associate member.
Same thing will continue. Same thing will continue. Only thing, his name, if it is written in the share certificate earlier, that will be removed.
It has to be removed.
That's correct. If he is not a owner of the flat. Now we have with us, Ankit. I think, we have got the next topic is related to management of a cooperative society. Nowadays, we are talking about digital India, we are talking about technology. Last 3 days we have been talking. Nearly few software people are also there. Ankit, you can just tell us as to how the software can make the working of the society much easier. What are the facilities that can be made available through the software?
Thank you, Prabhu sir, and thank you, guests. So we launched a product in technology by the name of MyGate. MyGate is nothing but an application which is used in societies for visitor management, for vehicle management, and also for complete community management solutions. Now, the idea behind finding MyGate was that whenever there's a visitor in your society, so either the entry is done on a register, but the problem is the entry done on a register is not an authenticated and authorized entry. So that was one of the challenges with respect to the visitor management. Second challenge that we saw was even if the technology exists in the security space in residential societies, it exists in an isolated fashion and comes with a huge capital expenditure. Like we use intercom, we use biometrics, we use boom barriers, RFID tags. So which is why we launched one product. It's a mobile application and it combines the application of all these technologies and gives in one app. Now through this app, we use a combination of two products. One is a guard app, one is a resident app. The guard will be doing entry of all your visitors, be it your mates, your delivery boys, or your guests. And Similarly, every visitor entry will be notified to the resident, and you may be in any part of the world, Mumbai, Bangalore, or maybe US. Whoever is coming to your society, to your flat, you will be notified on the same app. And similarly, about your vehicle also, any vehicle, let's say a guest vehicle or resident vehicle can be checked in, checked out of the same application. Plus, we are also launching other community management features like billing, accounting, complaint management, notice management, everything through the power of our technology in one app.
Okay. I think cooperative housing society management can be well done with the various software. Now we have with us Advocate Uday Varanjekar. Sir, we welcome you. Before you could come, I think you are well versed with the legal system. As you know, now there was an ordinance which was issued to amend and bring a new chapter in the cooperative housing society. That was introduced on 30th October 2018. And it was converted into bill, and it was presented in the assembly. And when it was presented in the assembly, the lot of MLAs raised certain issues related to certain provision. One of the provision is 25,000 penalty will be levied to the office bearer if they don't give the information which is demanded. Then the election of a housing society which is less than 200 members will be done by the societies. And there are other issues. And because of that, the bill was required to be taken back. However, the ordinance, the question is, the bill is not passed. Now ordinance says new chapter has been done, classifications of members are done, rights are redefined, lot of issues have been raised. Now having taken back the bill, what will happen to the working of the society? Will the old law prevail or the new ordinance will prevail?
Firstly, I must say I'm sorry I was out of town. We all are aware about the Mumbai traffic. Though I promised to reach at 2:30, I must express my difficulties and say sorry to organizers and all participants who are here. The question is a legal question. Once ordinance is passed and it is treated as a provision of a statute, so therefore, as on today, the ordinance is converted into, ordinance is resulted into an amendment in the Act. As a result of that, that amendment continues till the ordinance lapses. This is a one view. Second view which is possible is, to replace that ordinance, bill was tabled. However, the government decided to withdraw that bill for whatever reasons. So therefore, life of an ordinance came to an end. This is the second view which is counter to the first one. If we consider the basic provisions of the law, then the life of an ordinance is for 6 months or till the bill is passed and it is converted into an act. So as a result of that, as on today, what is the situation? According to me, the amended provisions are there. Those amended provisions are applicable to the housing society, and therefore I must congratulate the organizers who have raised this valid issue, because most of the housing society management members, they are carrying some kind of a confusion in their mind as to whether they will have to abide by the amended act or they should withdraw, they should wait till the new bill is introduced. Now we all are aware that the bill can be introduced in the assembly itself. So therefore, unless and until the assembly starts, the new bill will not be tabled. What is the remedy before the court? Remedy before the government? October is a starting point, so therefore 6 months. Before 6 months, before expiry of the 6 months, now in the month of January, February, the assembly will start once again. And at that point of time, they will have to introduce. If they fail to introduce, then what will happen? They will have to perhaps go back to the Honorable Governor and issue a ordinance once again for continuation of the effect. That is a legal answer to this. Now the question will come, what will happen to those offenses, if any, which have taken place during this window period? Window period in the sense from October till whatever the next. The law is also clear on that. If some cause of action has arisen during that window period, namely during that ordinance period, then that will have to be tried as per the provisions of the law which was there at that point of time. Usually the courts are deprecating, courts are rather time and again courts are saying that ordinance after ordinance should not be there. A classic example of a matter which is reported by the Honorable Supreme Court of India, in which on 12 occasion ordinances after ordinances were issued, and therefore the court used this word, ordinance Raj should not be there. So therefore now, at least qua this subject, it is expected that maybe in the next assembly or next to next assembly, maybe in the month of February or maybe thereafter, it is possible that there may be a discussion on this topic. Thank you.
Amit ji, you may be aware that cooperative housing society elections, as per the 97th constitutional amendment, was supposed to be and was held or conducted by the Maharashtra State Cooperative Election Authority. Now in the new act, which is an ordinance which has been issued, it said that up to 200 members, 200 and less than 200 members, the society will conduct elections themselves. So when the 97th constitutional amendment says, constitution says election has to be done by the State Cooperative Election Authority, and the ordinance says it can be done by the society. How you look at this?
See, every state has a right and the authority to amend and tailor-make some of the provisions of the law. I'll give you an example of RERA. When RERA, I was at a part of the drafting committee at the national level and in charge for the Western India when the drafting was going on. In general, I would just like to ask, I'm just asking a question off the track, do you think RERA is effective or no now? Because at least you are safeguarded to some extent. Now the screening happens at the start itself. Earlier we had to rely upon it at a later date when the case is filed. Now the screening is done at the start only. So every state has the right and the authority to amend the provisions to tailor-make to their requirements of the state. In general, when the Cooperative Act was amended and when these election issues came up, actually the government, this government want to empower people to be more independent and self-sufficient without an outside interference. So what happened when earlier, prior to this change, when even a 10-member society was there, they have to still approach to the state election authority, then it goes to Pune, then it comes to the local register office, then the person appointed, it used to take 4 to 6 months time. So the empowerment actually was taken away rather. Even earlier, if you see that administrative was so easily to be placed in a society, now it's not that easy. So the empowerment, to empower the people of a cooperative society, these changes are done. And on an average, if you see, 70% or more societies in Mumbai are less than 200. And by this provision, actually you are empowered now. You are empowered to be self-sufficient without an outside interference and take care of yourself.
I would ask the same question to Varanjekar sir. Can there be a fielder and the umpire? They should be different? Or can the fielders themselves become the umpire? Or do you think a free and fair election can happen if the elected body themselves appoint an election officer and then they get elected or allow somebody else to get elected? What is your view on that?
Around 25 years back, we were not aware about the entity by name Election Commission of India. Let us go back to the history books and let us find out who was that person who introduced us with this particular name, that was T.N. Seshan. Till that point of time, we were not aware that this entity is there from 1950 when the constitution came. Now thereafter, we became aware about some more terminologies like free and fair election. That free and fair election was missing all throughout till this T.N. Seshan started implementing his powers. On the same line, when we consider about the elections of the cooperative housing society, obviously there was a need for a regulatory body who will look into the affairs of the conducting of the election. But the question is the cost, question is about infrastructure, question is about the all arrangement which is required to be made for conducting the election. We are aware that the state election authority is having their office in Pune, but there is acute shortage of a staff. Now there are large number of such entities which are having a shortage of a staff, but they are functioning. Now, unfortunately, with reference to less than 200 member society, the demand was there that rather we should be excluded for whatever reasons. I am of the view, I would like to differ with Advocate Mehta, who is next to me. I would like to say that, sorry, the election has to be conducted by independent, impartial authority. Take a case that the earlier body is there, then there are some likes and dislikes. There are the persons who are there who may say that, all right, let some third person be there as an observer, but still there will be a problem. So therefore, let the election be conducted by an independent person. That is my personal view. Since you asked me a question, what will happen, who will be a better person? So therefore, according to me, unless there is a third person who will take charge of the process of conducting the election, I am afraid the process will not be a fair, process will not be a transparent, and there is an apprehension that it will be a breach of the principles for which the 97th amendment was introduced. No doubt, as I said, these are my opinion, and ultimately, from a practical point of view, the government decided to exclude those societies who are having less than 200 members. Let us consider this excuse also, this kind of a reasoning which is given by the government. Is it possible for the Election Commission of India to say that we will not conduct election of Pondicherry? We are aware that Pondicherry is a very small place where the constituency is like one small ward from Mumbai, but the elections are conducted by the Election Commission of India. Whether we have heard by saying that the Election Commission of India has given their negative answer for conducting the election of a Gram Panchayat where 7 members are required to be elected? No. Why? Because free franchise, then free and fair election, transparency in the process of election, these are the basic pillars of the democratic pattern which we have adopted. On the same line, my view is that there is no need of exclusion of the societies who are having less than 200 members. Instead of that, the proper remedy would have been to strengthen the mechanism of conducting the election and give some sufficient manpower to the election authority. Thank you.
Yeah. Madam, I think you can give your views. What?
Even I am scared about that. Sorry, we are working as a forum. We are working in the field. Even I am thinking about my society. I am scared. If I am secretary and in the AGM I have to conduct the elections. So he is my member. He is my member. You come in the committee. You come in the committee. So it's very difficult to work then. So I'm totally agree with Varun Jikar sir. Whatever he explained about this election process, and really we scared.
Can I add a couple of minutes? The State Election Authority around 1.5 years back requested on a telephone call that can you recommend some good lawyers, because they wanted to build their own panel for the entire state of Maharashtra. As they were in search of a good lawyer, so therefore they said that the practical situation, we don't have staff with us, so therefore we are searching for a good lawyer. So instead of we searching somebody, can you recommend some good lawyers? So I did my job by recommending few good lawyers who are on the panel of the State Election Authority. But the fact remains that is a mechanism which is introduced with a good noble cause. But as on today, unless the mechanism is strengthened, I am afraid the objective will remain on the paper only. Thank you.
Thank you. Now we are on the transparency and on the easy functioning. Now we have with us Sunil Deshpande, who is also having a housing society software. So you just tell us, as a software, how it can help and how the management can be better.
Yeah, actually the most important part in management is the accounting part and billing part. And that is also, it should be charged, every charges should be charged as per bylaws. So there are so many societies, those are not following these rules, like sinking funds and all these things. So basically they should follow bylaws. They should go on that bylaws track. Even document management also is a major part in this thing. So documents are not properly maintained. I register, J registers are not properly maintained. So those should be properly followed. And that can be done through digitization. Like just Modi said, ki digital India. So all societies should be digital. All documents should be in digital formats. So anytime those can be recovered or maintained. Because there are so many incidences ki there is a flood and all documents are destroyed. And so many societies, they don't have even their I forms and J forms. So better the digital way, use proper software and digitize your society. That's the. Thank you, sir.
वारंजीकर साहेब, एक प्रश्न असा येतो की what we have is in a housing society, minority versus majority. Now you know that we are in the era of, because of TCPR 2034, now a lot of societies in South Mumbai as well as suburb, they are looking for redevelopment. And of course, major repairs sometimes. But the question is whether to go for self-redevelopment, redevelopment, all this. Now minority versus majority. Now there was a question yesterday that in the self-redevelopment you want 100% consent. When we are appointing a developer, we need only 51% consent, majority consent. So why one would go for self-redevelopment? Can you throw a light on majority versus minority? How the management of a housing society can be functioned and how we can take minority into confidence and implement the decision that is taken by majority?
Very interesting question, and the scope of your question is much, much wider than what I expected. I thought you started with the issue of minority and the majority, so therefore you will stop there. Then you entered into redevelopment versus self-development. Then thereafter, how to implement the provision, how to implement the decisions. Very wide. Let us go one by one. Till recent times, all authorities were against the self-redevelopment. I recollect around 5 or 6 years back, Mumbai District Central Bank had taken some initiative in which they prepared their own policy decision which will promote self-redevelopment. I recollect hardly few examples are there in the entire Mumbai which can be considered as a good example or a success stories of self-redevelopment. Why there was no inclination for self-redevelopment is a different issue. But if we compare development and the self-redevelopment, then obviously now the time has come when we should consider pros and cons of both these systems. Whether the benefit will be rather shared with us or whether the builder developer will be entitled to get the benefit, whether he will be there who can enjoy everything or whether he will give us a small piece of the butter and he will rather take the entire cheese, that's the issue. That decision the society members will have to take. Coming back to the minority versus majority, that conflict is always there and it will remain till the entire Cooperative Society Act framework is there. So therefore, if there is a minority view which is expressed, then we are aware that in respect of such opposition, usually people go and start creating a nuisance value. We are aware the nuisance value is of three types. One, making an application under the provisions of the RTI Act. Now to the society also, and if you fail to give the reply, then 25,000. So nuisance value. RTI to the authorities who are supposed to look into the applications. Different application, different permission, different NOCs and all kind of permissions, etc. which are required. Third type of a nuisance, second type of the nuisance value would be ask different kind of documents to the society, not under the RTI, but ask those documents as a member by saying that being a member, it is my valuable right to get all those documents. Most of the societies are poor on documentation. That is our practical experience. They may be doing good activity, they may be taking good decision, they may not be utilizing single pie for themselves, but still most of the societies are poor on their documentation aspect. So as a result of that, if somebody asks the documents, then the society people start feeling that, the management start feeling that, no, this is a person who is likely to create some hurdle, so therefore go slow, or rather try to avoid giving reply to those applications. The third possible nuisance would be going to the registrar. Obviously, the registrar is having a very limited control so far as the process of AGM or process of a special general meeting is concerned. So take a case that if there is a decision which is taken in the special general body meeting, annual general body meeting, then obviously the member who is in a minority will be having a very, very few options. That option will be, if he is agreed to go to the cooperative court. He will have to go there, he will have to file a proceeding and then spend some money, and then based on that, carry that matter further. So the seeking a redressal will be of twofold. First is the registrar or the cooperative court. This nuisance value which is likely to be created by the minority member usually hampers in the process of development, redevelopment, self-development or otherwise. Therefore, it is better to take them into confidence. Usually, how you conduct the AGM as a chairperson, how you conduct the AGM, that makes a difference. Large number of occasions in a AGM or in a special general body meeting, what you are supposed to do, you will have to acknowledge the point which that person who is in minority is raising. It is possible that that person who is raising some issue may be saying something logical, may be saying something illogical. But as a person who is supposed to chair that AGM or a special general body meeting, you will have to take him into confidence and then put that resolution to vote, and then based on that, go ahead with the decision. It is possible that that minority person may raise something irrelevant. But as a chairperson, you will have to control that entire affairs of the society in such a manner that he should feel that his voice has been heard in the meeting. As a member, what he is having? As a member, he is having an expectation that I am having concern about the issues which are likely to be discussed in the meeting. So therefore, please hear me, mark my protest. It is possible that there are some minority members who are more interested in marking their protest and noting it down in the minutes. They are happy with that. They may not go beyond that. So therefore, if you are a proper person who is having some tips which we are sharing, then you can definitely say that, all right, you have raised a worth point, we are noting it down, and then thereafter, by majority, you can take a decision. The confidence which is required to be shown in that minority members of the society, that is more important. He should feel that, yes, I have been heard. He should feel that ultimately it's a common activity. He should feel that I am also part of this entire affairs of the society. I think that is a skill which the chairperson or somebody in the managing committee will have to show. The last question which was asked by him, how to implement those decisions. Usually, take a case of a MAHA. If a MAHA property is there, then we are aware 95A, the remedy is there, 66, that remedy is there. You can go to the MAHA, issue a notice through MAHA for eviction of those persons who are against the development, redevelopment, self-development, whatever. If it is a CIDCO, then the remedy is different. If it is some other SRA, then again remedy is different. So you will have to consider which is that remedy for implementation of your decision. It is possible that it is pure cooperative housing society which is not controlled by MAHA, CIDCO or SRA. Then whenever possible, you will have to point out that because of this one person or two persons who are in minority, the interest of the majority is likely to be affected. And therefore, you will have to request to the court that please do not grant any injunction in favor of this person who is in minority, because the majority is likely to suffer a large because of one or two unsatisfied persons. Ultimately, the question was how you can put your decision into execution. Large number of housing management committee members are good. They are loyal to themselves, they are loyal to the society, but they may not be good executor. To execute a decision, the skills are different. Therefore, according to me, to become a good executor, some more tips are required, and perhaps one more session will be there for how to implement the orders of the decisions of the cooperative society. Thank you.
Thank you, sir. Thank you. I think you have nicely explained. Now let us go to Advocate Amit Mehta. Sir, in a housing society, there are different laws which are applicable. Maybe there is some dispute related to water supply, there is a parking issue, there is a, minutes writing issues, there is a implementation decision. Which are the authorities where a housing society management or a member can redress their different disputes, redressal disputes?
See, whatever I'm talking, I'm not talking as an authority of being the part of the government, because I'm heading the legal department of the ruling party. But by and large, generally a member is always a litigant. Let's understand the mentality of a person. Okay. So what happens in a cooperative society, when the government enacted the laws, they thought that, a lot of the society members, they are going to be litigants for even small issues. So they started the system of register, deputy register. So your first point of contact is always a deputy register. So one of the person is going to lose in that, either the society or the member. So in the aggrieved party, he goes for the appeal to the DJR, the Divisional Joint Register, who sits in Malhotra House. Now there is a possibility that under some provision, you can even go directly to the cooperative court, or then go for appeal to the Mantralaya. That is a cooperative minister of the state. So the person who loses now will go to the cooperative minister of Maharashtra. Then the person who loses will go to the High Court. And then finally it will get settled in the Supreme Court. Now this procedure takes almost 6 years' time. So first you should decide whether when you are empowered, being a managing committee in as per the new bylaws, lots of settlement are now happening within the society only. So the cooperative society managing committee is now considered as the managing trustee of a society. And you being the trustee of the society, you should try to ensure that there are less litigations, because everyone may have a viewpoint, and finally the majority prevails. As Uday said just now, in the minority versus majority, okay, the majority would always prevail. But if the minority has a very valid point, I have got stay orders only just by getting one member who is right and all others are wrong. If the majority ultra-vires the law of the land, you understand that minority is 100% going to win. And in redevelopment matters, that's where, the entire crux of the matter is, ultimately. FSI, TDR, extra corpus, extra rent, shifting charges, to and fro charges, all those things, brokerage charges. So everyone wants to have a say in the pie of the cake. And that's the time when this minority and majority is going to play an important role. In general, when litigations go to deputy register or divisional register, you understand the person who is having a good study on the subject normally wins. And if you want to go into litigation also, a particular subject, you should be well prepared. Be prepared before you go. When you go to a person like a divisional joint register or even Mantralaya, by general natural law of justice, you would normally get a stay. That till such time, I am finishing off this matter at some point of time, I am going to give a stay. That is, natural justice is given. That is bound to happen, whether it is a society or a minority member. But my urge to all the members is that you should be well prepared, you should study well the subject, and don't go unprepared. Because many of them, some of them are managing committee members and some of them individual members. Each of them have an important role in your society. And when you're taking over, being a part of the managing committee, you should be well read. You should be well heard also. And the authorities where you are going, they should also feel that there is some reasonable guy who is coming and arguing the matter.
I wish to place a different thought before all of us. I agree with Advocate Amit Mehta. Cooperative court was established prior to giving power to the registrar, I can say. So the first is civil court, then some part is given to the cooperative court, some part is given to the registrar. Then after registrar, the authority comes under Rule 107(19)(c), sale officer, etc. Still, all these authorities are having substantial litigation. If any of the member goes to the registrar, you will find he is required to wait in the queue for months together. If you go to the Divisional Joint Registrar level in Mumbai, then obviously couple of years are required. If you go to the level of the minister, then again the state government will take at least 1 year time or 1.5 year, 2 year time for deciding. If you go to a high court, then obviously there is a bottleneck and nobody is in a proper state of mind to say how many years it may take. Now the time has come when we can introduce some kind of a different mechanism as a redressal agencies. No doubt, here this agency is already there. Let us consider what are the other schemes which are available as an option. And I'm sure you will definitely consider and look into it. If we go back to the 2002 amendment in the Civil Procedure Code, the situation is similar. The civil courts were overburdened, therefore, Section 89 was introduced in 2002 amendment by virtue of which mediation was propagated, by virtue of which alternate dispute resolution mechanism was introduced. Now, we are in 2018, large number of litigations are there. You will be surprised that in the office of a registrar, every day somebody is coming with a grievance that please look into this and issue appropriate direction. We are aware in the scheme of the Act, there are large number of provisions which are giving adjudicatory power to the registrar. Adjudicatory power in the sense, he will have to decide X is correct or Y is correct. There are certain powers which give a supervisory jurisdiction. Certain powers which treat registrar as a custodian or a trustee. So therefore, all these powers are there. Looking from that angle, now there is a need for introduction of some mechanism where parties can definitely go for redressal of their grievances out of this entire judicial mechanism. How it is possible? Like this forum, like Mrs. Godbole's forum, like MSWA, they can come forward and say that we are independent authority, we are ready to mediate between these two fighting parties. Time has come when we will have to consider whether going into the litigation either before registrar or cooperative court or divisional joint registrar or before the honorable minister is a good proper option before all of us. Therefore, the question was what can be done about the different issues which the honorable member of the society will be facing, maybe for water, maybe for property tax, maybe for the parking issue, maybe for non-occupancy charges, maybe for other different issues. If there are some disputes, then let them come to some independent authority who can look into it, who is well versed with the this theory, namely the legal topic, well versed with the practical aspect, how they are running. And therefore, my suggestion to the forum and the authority would be that can you consider of preparation of a panel to whom those disputes can be referred. A panel will be there who are volunteers, who may charge something, may not charge something. But if those issues are redressed at a proper point of time, then it is possible that the society will save a large as well as the individual will also be benefited. Thank you.
I think you have made a very good point. In fact, one of the mandate of new ordinance before issuing in this, can there be a regulatory authority for management of a housing society to dispute redressal? The way we have got real estate regulatory authority, the proposal was housing regulatory authority, cooperative housing society regulatory authority, who will have 2-3 members, and every complainant will pay certain fees, and that fees will help for setting up this system. But some or the other, that was not recommended or accepted by the government, and maybe they are looking at some other alternatives. Now the question is open to you, all of you. We will have 5 minutes to have any questions from the forum to the panelist. Yeah. Huh.
Okay. So if I
give in detail all the mistakes to our advocate Amit Mehta, because he is the
legal head of the BJP.
ruling party. I have given in writing all the mistakes which I have found out.
Sure.
And he can take it forward.
Absolutely,
So
it will be his pleasure.
When this is put up next time, when before it is placed next time, the bill is placed in the Legislative Assembly.
In fact, I am telling you, go one step ahead. Even RERA amendment is going to come very soon. So you can give 2 points that also to Ramesh Prabhuji and we will take it further. I think you centralize with him so it is easier to communicate.
And that should be the procedure. You will have to approach the organizers. Their organizers will forward that to the concerned subject expert. Myself, Amit, we are subject expert. Please do not contact the subject expert by bypassing the organizers.
Or it will be chargeable.
No problem. Sir, you are welcome.
That was not the intention, but since I know Mr. Mehta personally, so
Yes. You are most welcome to you.
It would be better.
Sure. You are most welcome to you. It will be highly appreciated.
Thank you.
Any other question? Yeah, you have one question. Yeah, please.
In 2005, there is a circular from Commissioner of Cooperation Pune. He has said 2 things. One is a dispute resolution committee in every society that sits above the managing committee. So if a member has a problem, he goes to dispute resolution committee and he tries there. If it's not there, then the society also has a good chance to get it. One more thing is lots of complaints about the improper recording of the minutes of the meeting. So he had suggested video recording of the minutes of the general body meetings. But those tools are not catching up or not taking place.
You want to say anything?
Sure. Object seems to be correct, but I must give a parallel example. When the issue was raised before the Honorable Supreme Court of India, whether there should be a video recording of what happens in the court. Everybody opposed. We as a lawyer, we oppose because we know some of us are having habit of making an irrelevant submission. Some judges are also opposing because they also know that they may be exposed if it is video recorded. The litigants are also opposing because they are perhaps feeling that whatever is their worth, that will be exposed if it is video recorded. Now, on trial basis, the Honorable Supreme Court of India said that in respect of some specified trials or specified cases before the Supreme Court, they may go for video recording. On the same line, large number of office bearers of the housing society, they are afraid of video recording of the management committee minutes, management committee meeting. We are aware what we talk usually is different than what we are talking online. We are aware what we use loose words in our different meeting should be excluded when you come and start preparing the minutes. As a result of that, large number of housing societies are against the idea of video recording of the minutes or video recording of the meeting of the managing committee. But so far as the annual general or special general body meeting is concerned, everything is happening. So therefore, at least qua that, there are minutes which are available. But you will be surprised, large number of members are not asking the copy of that video recorded minutes or video recording of that meeting of the AGM or special general body. If that is so, then what is the use of spending few more thousand on video recording of that entire minutes or entire meeting of that AGM or special general body? According to me, this is a facility which is provided as a safeguard. Tomorrow you should not doubt or nobody should claim that I said so, but you have not recorded, or this issue was discussed or not discussed in the society. So my appeal to all participants who are here would be that whenever there is a doubt of single percent in your mind, please raise your voice and ask for the copy of that video recording of the special general body meeting or the AGM. Most of the societies are maintaining this for a couple of years or 3 years. So therefore, you are entitled to get at least for 2-3 years. There is no difficulty about that. Coming to the second issue which you pointed out, that there should be a redressal committee. Unfortunately, this is remaining on paper. Therefore, as I said that who will be a member, who is going to come forward, whether they will get some remuneration, whether they will be entitled to have a sitting allowance, all these different issues are there. Looking from that angle, I gave a suggestion few minutes back saying that now it's a time when some authority or some forum should come forward and show their willingness to serve the entire community as such. Maybe initially they may charge for some nominal fees, but if the disputes are referred to that independent authority, then there are chances that the redressal of the grievances may happen instead of approaching to the lengthy queue and joining the bar where we are available otherwise. Thank you.
I agree with you. Wait, just 1 minute. I agree with you. Last view I'll take. There should not be two managing committees in the same society, because you just pointed out one line saying that if you are not happy with the committee's decision, or the committee is not agreeing to certain things, you will go in the redressal committee, which is above the managing committee. So within this society, there should not be two powerhouses. The debate happened in the assembly. Thereafter, what was proposed in the bill was withdrawn. So redressal committee is right now, it is not there. But I do agree with what Advocate Uday Varanjikar is saying. Maybe we can have a system of panel of arbitrators, which is there in the Multi-State Cooperative Societies Act. That arbitrator can be appointed in the general body, who will be able to, decide. He is an independent third party, and those arbitrators are empaneled by the registrar. It becomes an easier one. That is the time which has come. Maybe we will look into it in the new drafting. Okay. With this, yeah.
Can I just try to mold it? Arbitration, once you go there, then you will find there is a different statute. If we go by the general provisions, then Arbitration Conciliation Act 1996. If we go to the multi-state, then 84 and the other provisions are there. Therefore, I suggested appointment of a mediator. Mediation is different than arbitration. Arbitration, obviously, there is some kind of a binding effect which is there. The laws are very stringent. Take a case that 84.5. 84.5 of the multi-state and read with section 34 of the Arbitration and Conciliation Act. If you do not prefer an appeal within the statutory period which is given, then obviously you will lose your right to prefer an appeal. That will be not advisable in the interest of all members of the society. Therefore, I suggested to begin with, let us try for mediation. Let there be a panel of mediators who are independent and who are having a background of good academic qualification, good practical experience also, and then go for mediation. Then if necessary, on the line of multi-state cooperative housing society, we can think of introduction of an arbitration system in the statute itself.
Okay. Thank you very much.
Okay, thank you.
You may have a lot of questions. We have got 2 more sessions, one related to redevelopment, another related to, again, management of housing societies, bylaws and all. So we'll definitely proceed to the next.
Thank you.
Before that, we thank each of the panelists.